This panel, we are here in this panel to discuss the relationship between the executive and the judiciary. And it's probably fair to say, I'm just going to set my timer going now, it's probably fair to say that the relationship between the executive and the judiciary has got very interesting, to use a euphemism, over the last 5 to 6 years. We had a very good email discussion between the three of us on the panel, Conor, Alison and myself, last week as to who was speaking on what aspect of this increasingly interesting relationship. And how we're dividing things up is that I'm going to sort of introduce general themes, try and wake you up a little bit. Secondly, you get to the real meat of the substance. You're going to get Alison talking about some of the judicial review and courts bill, Ousted Clauses and various exciting things like that. And then Conor's going to talk to you about Human Rights Act reform, the Great British Bill of Rights, and other exciting new developments in that field. So I'm going to sort of lay out, I think, a general thematic introduction to what's going on and try and pick out, I think, some salient themes in the unfolding relationship between the executive and the judiciary. It's important to remember, of course, that the executive-judicial relationship is rarely completely harmonious, putting it mildly. And this is probably true of every legal system in the world, except perhaps for Russia and China and a few states where the judicial-executive relationship flows very smoothly indeed, for reasons we all know. The executive-judicial relationship is inherently tense. Even if government ministers are winning high-profile cases, they always, of course, as everyone in this room will know, will have to deal with their civil servants or their legal advisors saying, well, that's an interesting policy, Minister, but it won't work because of the lawyers. Or, that's a fascinating policy, Minister, but it's got a 70% chance of being overturned in the divisional court, etc., etc., etc. So the relationship between the executive and the judiciary is always a little bit potentially fraught with tension. And it's important, given the current context of very real tension that's existed over the last few years, to bear in mind that there has rarely been a golden, harmonious era of executive-judicial relations. I mean, the example I always like to highlight, if you go back to what many people feel is the golden era of the historic political constitution in the early 1970s, that Lord Donaldson, as he later became, subsequently Master of the Rolls, when he was chair of the National Industrial Relations Council, was fondly referred to as Black Jack by Labour backbenchers because of his views on industrial relations, and indeed something like 150 Labour members of the House of Commons signed a motion calling for him to be dismissed, okay, in the early 1970s. So it's important to remember, just throwing that in from the golden days of the political constitution, so to speak, of harmonious constitutional functioning, it's important to remember the judicial-executive relationship has always been prickly. We had the recent spectacle in the House of Lords Constitutional Committee, with Lord Reid and Lord Hodge giving evidence to the committee, facing quite robust interrogation from Lord Howard, Michael Howard as was, on the Miller 2 judgment. And this occasioned quite a lot of outrage on Twitter. I reminded a few people, and I wouldn't underestimate some of the tensions in that particular exchange, and I'll come back to that. But I had to remind a few people that, of course, Michael Howard taking a robust attitude to judicial judgments isn't a radically new development. It is, in fact, a mid-1990s retread. So it is important to bear in mind this inherently prickly relationship. Having said that, it is clear that the basic equation of the judicial-executive relationship has become more fraught in recent years. There are more points of tension. And the manner and mode of these tensions and how they're playing out has become increasingly confrontational. Okay? How I like to put it is that the basic functioning of the system, where the executive tries to govern the country in line with what David Howarth and others citing Birch's 1960s work, referred to as the Whitehall vision of government, try and rule the country according to their own lights, and the judiciary sometimes get in the way, sometimes facilitate that by interpreting the will of Parliament with reference to fundamental constitutional principles. That basic equation has become complicated in recent years. And I want to draw out certain reasons, I want to draw out certain factors that have contributed to the mode and manner of this relationship becoming increasingly fraught. To start with, of course, we've entered a new political era. Okay? We've entered a political era where we have a government, successive Conservative governments, it's probably fair to say at this stage, who are elected on a policy and using a rhetoric of shaking things up, of challenging the status quo, Brexit being the single most obvious example of that. And as part of that challenge, government's been elected on a challenge of shaking up the status quo, you inevitably have a politics that becomes quite confrontational and that has focused on aspects of the existing constitutional settlement. The separation from the EU was always going to get fraught on the legal battlefront. The tensions with the ECHR in respect to human rights law, there's always going to be a degree of tension there, okay, given the particular political context in which we're operating. This tension gets expressed, this tension with its roots in a challenge, a Conservative challenge to the status quo, has got expressed in a number of different ways, what I call different modes of expression. First of all, you have the government, and in particular successive Lord Chancellors, strongly asserting the primacy of parliamentary sovereignty and the need for judges to defer to the assumed intention of Parliament. This has been particularly clear in the series of extremely interesting speeches made by Robert Buckland when he was Minister for Justice and Lord Chancellor, which I think in many ways should be essential reading, because they are very interesting speeches in a number of different ways. Robert Buckland in his speeches was repeatedly making the point that parliamentary sovereignty entails the primacy of Parliament, and that the UK Constitution as structured did not necessarily recognise some sort of free-floating role for judicial norm generation, for judges to sort of have some sort of free-floating role as guardians of the Constitution. The role of judges was to give effect to the will of Parliament. Now that's controversial, it's interesting. Put a group of lawyers in a room, you can have endless arguments about it, but it is one interesting aspect of the current set of tensions, the strong reassertion of parliamentary sovereignty as the keystone of the UK's constitutional settlement, and the need for judges to, if you want, respect and defer to the assumed intention of Parliament. Which is why, for example, Robert Buckland zeroed in on the Ousted Clause judgments of Evans and Privacy International. You know, the argument that it attempts to oust or at least restrict the jurisdiction of the superior courts in relation to FOI matters and other matters, that the Supreme Court had taken upon itself to read parliamentary legislation clearly against the grain in a way that he has argued shows insufficient respect for the cardinal sovereign or central orientating principle of the UK Constitution, parliamentary sovereignty. So that's been first theme, if you want, to our contemporary tension, strong reassertion of parliamentary sovereignty. Secondly, a strong assertion of the importance of the executive role in governing the state. So we've had a strong stance taken by both the May and Johnson governments, emphasising the importance of the executive, the need for the executive to have a certain freedom in how it governs, in how it determines policy and how it implements policy, a much greater insistence, if you want, on the prerogatives, literally, of the executive. Okay. This is particularly striking in both the Miller cases. I'll draw your particular attention to a facet of Miller 1, which has probably been slightly neglected, which is, of course, that Miller 1 and all the excitement it generated was in many ways a completely unnecessary diversion from the core business of Brexit. The government of the day could always have got through its triggering of Article 50 on a parliamentary motion with great ease, as it did when forced to do so by the Supreme Court decision in Miller No. 1. There was never any particular political reason for the government to fight in the trenches as hard as it did to assert the executive prerogative to trigger Article 50 of its own volition. Okay? But what was going on there was a deeply felt need within government to assert the executive prerogative, leading to that famous and controversial set of litigation and the rhetoric of enemies of the people and so on. I think that's a somewhat neglected aspect of Miller No. 1. The insistence on executive prerogative, on the free role of the executive, so to speak, in the context of foreign affairs. So, first of all, strong reassertion of parliamentary sovereignty. Secondly, a strong, even confrontational reassertion of the particular role of the executive. Thirdly, a robust attitude, putting it mildly, what the French might call a roast beef attitude, towards the UK's international law commitments, as evidenced by its repeated, I say repeated because it's breaking news today in the Financial Times about potential new legislation in relation to the Northern Ireland Protocol, repeated legislative proposals that would appear to put the UK, at the very least potentially, in breach of its commitments under the withdrawal agreement to the EU. We're also seeing robust attitude towards certain aspects of the UK's obligations under the European Convention on Human Rights and other aspects of its international law commitments. Okay. I say robust because, of course, you can have interesting arguments as to how far the UK is in fact complying with its international law obligations. And we're seeing this being played out now in relation to the controversy around the Rwandan proposal, where the government is arguing that it's fully compliant with the Geneva Convention, despite the views of Lord Judge, former Lord Chief Justice, and others in the House of Lords that the government isn't complying, that the Rwanda proposal won't comply with the UK government's obligations. But what you're seeing there, I think, and I use the term robust in this way, is maybe not necessarily a set policy to breach international law commitments, but certainly a robust confrontational stance towards these commitments, or at least a reading of these commitments in ways that might push against the grain of conventional understanding of what some of these instruments entail. Okay? So we see, therefore, these three different modes of sort of assertion. Emphasis on parliamentary sovereignty, emphasis on the role of the executive, robust emphasis on the UK's international law commitments. Okay? Now, what is unifying all of this is a sort of an assertion of the central role of political decision-making within the UK's constitutional architecture. And again, to go back to a rather interesting speech that Robert Buckland made to the Constitution Unit in UCL last year, he quoted something I had written on a blog to the effect that the Conservative government was trying to reassert the old traditional political constitution of the UK, to sort of set the clock back, to push back against the gradual expansion, as they would see it, of judicial power that has happened over the last 20, 30 years, and to assert the primacy of the political in decision-making. I thought it was interesting that Robert Buckland explicitly cited my analysis in that regard and quoted me expressly as indicating that as to the overriding aim of the government. This, of course, raises all sorts of interesting and difficult questions. Firstly, it raises all sorts of tensions because, of course, the UK is enmeshed in a series of international commitments. Its continuing treaty obligations to the EU, its obligations under the Good Friday Agreement in relation to Northern Ireland, its obligations under the ECHR and Geneva Convention. So the reassertion of the political is rubbing up against all these international law commitments with the inevitable legal judicial apparatus associated with all of these different treaties. It's the assertion of the political is also rubbing up against the judicial role sometimes in policing separation of powers, in preserving the space for parliamentary decision-making, as in the two Miller decisions. It's rubbing up against attempts to rein in executive power, and sometimes this battle has been fought out in the corridors of Parliament as well as before the courts. Okay? So but there's a unifying theme here. a reassertion of the political, of the autonomy of executive decision-making, with rather interesting claims being made about how the executive has a freestanding mandate from the people by virtue of general elections, of people voting for a manifesto, of a clear victory in the general election in 2019. So we've had some really fascinating arguments over the last 5-6 years in law journals, on Twitter, about whether does the executive have some sort of separate, distinct mandate derived from its victory in general elections, separate and independent from its support from the majority of MPs in Parliament. It's very much a hetero-orthodox view. I see one or two proponents of that hetero-orthodox view in this audience, but it remains a hetero-orthodox view. My favourite moment of these constitutional debates over the last 10, 15 years was of the last 5 years, when people started citing Queen Anne's veto of the Scottish Militia Bill in 1707 as an example that the executive retained the power to advise the Queen not to give assent to legislation passed by the Commons and the Lords. I found that set of arguments extraordinary, the notion that there was this lurking executive veto, which has sort of run on a sort of submarine basis of the UK Constitution for the last 300 years. But it is interesting that these arguments were being made by not just legal academics on Twitter, but also by legal advisors working very, very closely with Number 10. Okay? So, in other words, what we are seeing is a reassertion of the political and the particular role of the executive within political decision-making, and a pushback against judicial power. The Judicial Power Project's legal writing has given ammunition to much of that pushback. I think there's an interesting distinction between the views of government and political actors within the government and the views of the Judicial Power Project. They're often thought to be the same thing. I actually think there's some interesting distinctions there, which you are seeing playing out, for example, in the government's proposals for reform of the Human Rights Act. But what you are seeing is this strong assertion of a much more, if you want, traditional political view of how the UK Constitution should operate. Two concluding observations attached on to this general analysis of what I see as this essential tension that's been running through developments over the last 5-6 years. First of all, as I argued in that blog post a year ago, setting the clock back to the sort of perceived good old days of the political constitution, where the judges knew their place and where government could get on with the job of governing, is actually a very, very problematic process. There never was a good old days where the executive was just allowed to get on with implementing its manifesto. Again, if you go back to the theoretical glory days of the political constitution in the 60s and 70s, that also coincided with Annette Minnick, Padfield, and the development of modern judicial review. You also had, of course, an entirely different context back then, where, for example, the trade unions had an effective veto on executive policy and key aspects of decision-making. Okay? So there never was this good old days of the political constitution. I think it's important to bear in mind. You also, of course, now have a much more diversified constitutional landscape. You have devolution. You have the continuing links to the EU, continuing links to the ECHR, all of which complicates the situation. Okay? So you're having an attempt to reassert the sort of executive prerogative of politics in the face of alleged judicial overreach in a context that is radically different from when that similar claims used to be made 40, 50 years ago. Okay? And as a result, you have some really quite intense tensions, some confrontational clashes, and some deeply problematic decision-making. You've had some very fast, some playing hard and fast with rule of law decision-making, actually, from government ministries. I would draw your attention very briefly, and I'm conscious of my time, to the recent decision of the Divisional Court in HM, which many of you mightn't have seen, because it didn't attract the same controversy as other recent controversial judicial decisions. But this was the judicial review, the legal challenge to the government's policy, the Home Office's policy of seizing mobile phones from asylum seekers coming across the channel with boats. I recommend you all read the judgment. It won't be appealed. But if you, 3 paragraphs into this HM judgment, issued in early March, there's an extraordinary paragraph where the Divisional Court notes that the government has conceded 9 separate points. Okay? 9 separate points of concession, a whole range of arguments relating to administrative law principles, Human Rights Act, data protection, non-compliance with the Immigration Act. In other words, the policy of seizing mobile phones effectively lacked any rule of law, any meaningful rule of law basis. And when challenged before the Divisional Court, James Eadie for the government, Treasury Devil, had to concede, had to make 9 separate concessions. Okay? Now, that is, I think, interesting evidence of a certain degree of playing fast and loose with rule of law constitutional principles, which I think is concerning. Now, this may be a specific problem for the Home Office, but it is concerning of an overall attitude that this reassertion of the political is taking us into some questionable water. The final comment I'll make, and then I'll shut up, is the rather interesting developments that have happened, perhaps in response, perhaps not, to this reassertion of the political, which is the rather dramatic shift in the Supreme Court's jurisprudence that has happened in the last 6 months even. It's rather interesting that we've had a sequence of very, very significant cases that I know Conor will talk about later. Elaine Kane, SC, passport fees, which have involved in many ways the Supreme Court rereading the Human Rights Act, recentering parliamentary sovereignty, reading down principle of legality as developed through common law, effectively reversing a sequence of decisions over the last 20 years by the Supreme Court, casting doubt on some very important precedents over the last 5 to 10 years. Cases like Adams, Northern Ireland Human Rights Commission, other cases would almost certainly not be decided the same way nowadays. So in 3 years or less, we've had a rather dramatic reversal in case law. And what's happening in the Supreme Court jurisprudence is an interesting reassertion, not necessarily of the centrality of the powers of the executive, but certainly a reassertion of the centrality of the political element of the UK Constitution via deference to parliamentary sovereignty. Now, combined with this increasing executive assertiveness, we are coming to a situation, I think, where judicial power has been or is being put back in its box to some extent. You'll have to decide for yourselves how useful and valuable, important or desirable or undesirable that development is. But we are seeing the foundations of the existing constitutional order change quite quickly in ways that are, I think, interestingly destabilizing and potentially very concerning. Thank you very much.
Good morning. I'll do my best also to project and pretend this light is a microphone. And again, if you can't hear me, please just wave. It's rather fitting that we are in this lovely ballroom because I think we've got a well-orchestrated dance between the three of us. So I'm going to start by picking up very briefly on some of the themes that Colm mentioned, and then, as was mentioned in the introduction, to try and talk you through some of the constitutional changes that are going on at the moment that I think illustrate these themes of a greater transfer of power to the executive and a reduction in the extent to which we have both legal and political controls over executive power. So, as you can probably guess, I'm quite concerned about this particular direction of travel. And like Colm, I don't think this is an idea of some kind of return back to the golden days. I'm concerned because I don't think this is needed. I think a lot of the evidence that is given for why we are pushing back against judicial review or the case is often based on a selection bias of a few cases that were taken in exceptional circumstances. So it's very hard to listen to any of this evidence without being told Miller 1 and Miller 2 went too far, Adams went too far, Unison went too far, Evans went too far. Maybe they did, maybe they didn't. My concern is it's a few cases in exceptional circumstances on controversial topics that seem to be leading the debate, rather than looking at the overall picture of how judicial review works in practice. I also think it's not necessarily needed because, as Colm has pointed out, and I know Conor has written on as well, I don't think this is an accurate picture of where the Supreme Court is at the moment. I think the Supreme Court is much more cautious, potentially legalistic, but it is concerned about maintaining mutual interinstitutional respect, particularly when it comes to obeying court orders. So I don't think this is a return to normal. I don't think there is a normal. I think there's constantly tension between the executive and the judiciary. And what's concerning me even more is I think it's returning to an aspect of political constitutionalism, which is much more concerned about having a strong executive, and where there aren't necessarily effective political as well as legal checks. So it's all very well returning to an understanding of political constitutionalism, but if we're going to do that, we need effective political scrutiny. We can't just reduce legal scrutiny, say, well, it's okay, politics will do its job. And I think my concern is there's a viewpoint that it's okay to have a strong executive because it is democratic. It's got controls from its political party checking on what the leaders are doing. It's got controls from Parliament checking on what is going on. And yes, that is true. There are these controls going on. But my concern is sometimes these controls are less about ensuring we have political policies that are in line with the wishes of the electorate, and more about shifting towards a kind of form of what I call pragmatic populism. Let's say what we think the people want, particularly those in marginal constituencies, say what we think they want to hear so we get their particular votes. And it's more about saying what we need and checking to make sure we maintain power, and less about thinking about policies. So what I want to do is talk you through some of the changes that are going on that I think are strengthening the executive and weakening, in particular, judicial controls, because we're looking in this panel about the relationship between the judiciary and the executive. And my concern is that these changes are reducing both formal and informal checks and balances. So by formal, I mean the extent to which Parliament and judicial review in the courts can perform an effective check. And by informal, I mean these aspects of things like mutual respect or self-restraint that are meant to run through a predominantly political constitution. And what I'm going to do is look predominantly at the formal, and there's going to be three things that I want to look at. First, I want to talk you through some lovely Ousted Clauses, one of which is now law, one of which I'm sure will soon be law, I would have been able to report on you as to what was happening on this one, but something happened in Parliament yesterday that bumped the political timetable, and so we didn't get the House of Commons looking at the Judicial Review and Courts Bill. That's been moved to, I believe, next Tuesday. Who knows? Something else might have happened by then, and it might be some other time, but the time's running out. So at some stage in the next week or so, we'll know where this is going. Second, I want to talk through a sort of more subtle ways in which you can try and avoid judicial review by using measures different from delegated legislation that either don't get judicially reviewed or get a much weaker form of judicial review. This idea of using things like policies and guidance, and my ultimate favourite, advice. And finally, I want to talk about the extent to which these changes could be used to dissuade people from bringing judicial review actions in the first place. And that takes us back again to everyone's favourite bill that may or may not be an act, who knows, in the near future, the Judicial Review and Courts Bill. So what are these examples of Ousted Clauses? Well, there are two examples of Ousted Clauses I want to talk through. The first is found in the Dissolution and Calling of Parliament Act, and the second is found in the Judicial Review and Courts Bill. Now, I accept these might be seen as limited and specific Ousted Clauses that could be justified in their particular context. But what worries me is, how far will these be used as a blueprint in the future? And how do we deal with subtle incremental shifts? Because I think a lot of what goes in our constitution is there for when the wheels really do fall off, we have mechanisms to try and stop it in these exceptional circumstances. But what happens when we have incremental changes that lead to a cumulative effect? Do we have the same ability to check them? So what's the Ousted Clause in the Dissolution and Calling of Parliament Act? Well, it tells us that the exercise or purported exercise of the revised prerogative power cannot be questioned in a court. Any decision or purported decision relating to these powers cannot be questioned in a court, and the limits or extent of these powers cannot be questioned in a court. So a lot of things cannot be questioned in a court. But what's important is the way in which it is worded. So in particular, we don't just have exercise or decision, we also have purported exercise or purported decision. Now those of you used to judicial review will realise, well, this is a cunning way of getting around Anna's Minute. Because in Anna's Minute, when you have a clause saying you cannot question this, a decision or exercise in a court of law, the court will say, well, what if it's purported? What if it isn't really a decision because a crucial error has been made such that this isn't actually a decision? So you didn't have the jurisdiction to act, for example, so therefore it isn't even a decision, it's a purported decision. So we can still question it and check. Well, you can't really, if express words said, even purported decisions or purported exercises cannot be questioned in court. Second, we have this idea of limits or extent of these powers. Now, those of you who are used to Miller and Cherry being mentioned in every single case will know, and every single talk will know that this is a way of dealing with the Miller-Cherry case. In that case, we know that common law limits can be used to check the scope or extent of a particular prerogative power. In that case, the prerogative power of prorogation. So here we have, you can't have courts questioning the limits or extent of the prerogative power of dissolution. That's not a reversal of the specific decision in Miller-Cherry, but it's a way of pushing back at that and saying, well, you can't check those limits either. So it's a very conclusive way of making sure an issue is non-justiciable. Now you might say that's perfectly acceptable. This is all about a prerogative power of dissolution, and because we're dissolving Parliament, we'll then have a general election, and so the electorate can decide. So maybe it is justified in those circumstances, but the question is this a blueprint that will be used in other situations? And I think, so I used to be able to think, well, maybe it'll all be fine. We can just trust those to dissolve when there's a good reason to dissolve Parliament. And I think in recent events, I'm no longer sure I can say that. So maybe we do need legal checks as well. The Judicial Review and Courts Bill has similar provisions, at least in its original form, not with regard to the amendments of the House of Lords, but who knows where we're going with those. So in its original form, again, you have this idea of you cannot have, look, so this is all to do with carte judicial review. So this idea of when the upper tribunal decides whether it will or will not allow an appeal from a lower tribunal decision. And the concern of the government was there were too many of these going through, it's taking up too much time, and it was only succeeding in exceptional circumstances. So they wanted to remove this ability of the court to judicially review a decision of the upper tribunal to decide not to hear appeal from a lower tribunal. So it's quite a technical, small area. And what the original clause that you find in the bill would say, again, the decisions of the upper tribunal are final, and then you get the lovely little clause further on telling you that a decision includes a purported decision. So again, it's another way of dealing with how the courts would examine Ousted Clauses and read them down. There's also a further element in there, which I think is their way of dealing with the case of Privacy International. So this is when we're told specifically that the upper tribunal has not exceeded its powers by reason of any decision made, and that the supervisory jurisdiction of the court does not extend to judicial review. And I think this is a way of specifically saying, this is us making it very, very clear you cannot review these at all. You do not have the power to review them. This is a clear expression of Parliament's will to remove judicial review for legal errors, because Privacy International makes it clear that Ousted Clauses will be read down in order to protect some aspects of legal errors, and I think this is designed to stop that route out. Now, the Lords weren't particularly impressed with this, so they have proposed some amendments, and instead of removing judicial review of decisions of the upper tribunal, they've kind of moved it one stage up. So the courts can supervise the upper tribunal, but that will be final and will only be allowed on limited appeal to the Supreme Court in very exceptional circumstances, on general points of law, or either the supervisory court or the Supreme Court must see this as something that ought to be considered by the Supreme Court. I think that is there to deal with two things. One, because a lot of decisions, of tribunal decisions, are in immigration law, and so there are concerns about human rights protections and need to have a final check. And two, to deal with what I call the Privacy International islands of law problem. What if you have a series of tribunals deciding general issues, all in a different way, but there's no supervisory jurisdiction to say this is what the law should mean in these circumstances? So we have a uniform interpretation of a generally applicable clause. So I think that's what it's there for. I don't know whether they'll succeed or not. We'll find out next week. If you want to place your bets, I'm going for no, but but by all means, be more optimistic than me and see if those amendments are upheld. Now, to be fair, this is either what you could call a limited ouster, or you could call it a complete ouster plus a limited statutory form of judicial review. I don't mind which version you use, but essentially the statute then says, well, you can have carte judicial review in very limited circumstances. So once you've removed it, here's what you can do in the original version. You can check it was a valid application to the upper tribunal. You can make sure the upper tribunal did not act in bad faith. They're always doing that. Keep an eye on them, make sure they don't act in bad faith. And of course, if the upper tribunal had a procedural defect that was so serious, this would amount to a breach of a fundamental principle of natural justice, you could review that too. So there will still be, even if the amendments in the House of Lords don't succeed, there will still be some forms of judicial review. And again, I can understand how you might say, well, it was taking a long time, there are too many failed applications, and even the House of Lords limited their form of judicial review to 7 days. So it's a very quick turnaround to try and make sure the process isn't abused. But again, the concern is, what if this just keeps happening? What if this blueprint works, we lead to other forms of ouster clauses in other situations? Because when these come in incremental changes, you're relying on past cases like Annis Minnick and Privacy International to reinterpret the clause and potentially read it down. But this seems to provide ways of getting around that. And then you're left with the ultimate sort of nuclear button, in a sense, of judicial review, which is to pick up the acts of dictum and say, in exceptional circumstances, if you were to completely remove judicial review, we might decide we're not going to enforce that law. And that's a very extreme measure. So it's a kind of safeguard for extreme circumstances. It's called the exceptional circumstances doctrine for good reason. But is that going to be enough if we have a series of these incremental changes that might cumulatively amount to the same in the long run, but which just comes in a step-by-step process? And if not, how do we keep an eye on these developments and make sure we don't end up in that situation? Now, you'll be glad to know that my next 2 points are much easier to make and much quicker and far less technical. So my second point is how to get out of judicial review completely. It's great. Now, this is where you can use things like policies and guidelines and advice. And if you look at bills coming through, there's lots of empowering of the government, not necessarily to do things by delegated legislation, but to go away and produce guidelines and policies. Now, guidelines and policies are much harder to challenge, and this is because of judicial review decisions to joint cases in the Supreme Court, RA and Secretary of State for the Home Department, and RBF Eritrea and Secretary of State for the Home Department. Now, prior to these decisions in the Supreme Court, there were various decisions in the Court of Appeal that had suggested that if you had a policy or a guideline and there was kind of an aspect of it likely to be, in certain circumstances, in its application to lead to an unacceptable risk of unfairness, you could strike it down. The Supreme Court said, no, this is a little bit too vague, we're not sure about this. So instead they've gone back to the line of cases prior to this development and said you can only strike down a policy if it authorises or approves unlawful conduct by those to whom it is addressed. So it's harder to strike down a general policy for being unlawful, but yet we're getting more and more policies and guidance coming through. The ultimate favourite is not even bother to give a policy or guidance, just give some advice. So in the Dolan case, one of the potential challenges was to the advice to local authorities to close schools. But it was advice. Because it was advice, then you can't challenge it, because it has no legal effect. But often in practice, advice does really have a legal effect. In some senses, we rely on it, forcing people to behave in a particular way. So in New Zealand, in the Borrowdale case, where you had advice from the Prime Minister and various ministers about where they could and couldn't travel, and it took, I think it was 6 days for the regulations to come in that gap, that advice was seen to have the same effect as if it had actually instructed you not to move, so it was restricting your freedom of movement, but it was contrary to the New Zealand Bill of Rights Act because that restriction was not according to law. So they kind of recognised the impact of advice, whereas our system is looking at and saying, it's advice, it's not legally enforceable, you can't challenge it. So the more you use advice, the more you can say, well, it's not legally enforceable, you didn't have to follow it, and so therefore there's no ability to challenge it. And finally, we have my third point, which is dissuading people from judicial review, which again is the Judicial Review and Courts Bill and the modification of remedies. Now, the Judicial Review and Court Bill, in its original form, will bring in suspended and prospective-only quashing orders, which might dissuade you from bringing legal actions because you might not necessarily get an effective remedy. And in the original bill, there's what has been referred to as a kind of nudge clause. So this idea of not requiring courts to only ever give these remedies, but saying they must consider giving them if it would be an adequate remedy, unless there are good reasons not to. Now, again, the House of Lords has amended this. It's removed that particular clause, and it doesn't like prospective-only remedies, but we're not sure where this will end up, and we'll find out next week. Again, my concern with this is it's dissuading people from bringing legal actions. And I think it could be problematic because if you're not bringing the actions in the first place, how can you have effective judicial review checks over these particular decisions? And my view would be, if you're going to have these kinds of aspects of suspended quashing orders, leave it to the judiciary to decide when this is necessary, because they're more the exception than the rule. But we'll wait and see where we end up. So my overall concern is this kind of blueprint of incremental changes, this understanding of the executive of being the strong, predominant force, the undermining of political checks in certain circumstances, and the potential undermining of legal checks. And I guess my worry is, what would happen if these series of small incremental changes just got us to a situation in which we don't have effective judicial review anymore, and what, if anything, could we do about that? So I'll go and sit down now before I scare you all to death. Thank you very much.
Thank you very much for having me along. Let's start with a tendentious term, banditry. The rejection of an independent judicial forum or forum in which to challenge decisions by the state. This rejection comes in many shapes and forms. One of the favoured in today's culture is to fix it. so that the judges do what you tell them, as in many jurisdictions. It is now becoming increasingly normal that judges deliver, I called it in a book years ago, neo-democracy. Judges deliver ostensibly independent rulings that are in fact compliant with power. Every now and again the judges are sacked if they misbehave, like in Poland. Every now and again they are so driven by the interests of the executive they will jail people for no reason whatsoever other than the order of the executive, as in Russia. And we needn't discuss, but we could add Hungary, and 2 of those 3 countries are within the European Union. There are 2 kinds of banditry which has emerged from this conversation. There is executive banditry, which is simply the executive saying they couldn't be bothered with the law. They're very busy. It's immensely important what they do. Once upon a time, like Mr. Orban in Hungary, they won an election, and so you have no business interfering with me. Executive banditry is in evidence and has been partly covered. The advice notion fits within executive banditry. If you were advised by Stalin's secret police to do X, you would do X. Now, Jolyon Maugham got into a lot of trouble for drawing an analogy between the saintly Dominic Raab and various other not-so-pleasant people. So let me make quite clear that I'm not doing that. Is that enough? But secondly and alternatively, there is legislative banditry. And that's a subtler creature. And that creature plays on our commitment to parliamentary sovereignty. That creature plays on the weakness we display in committing ourselves to political constitutionalism. That weakness is on display in the bill to which Alison referred, which is going through Parliament, where it is legislated that you ignore the courts. That is a very, very challenging one. But so is executive banditry. They're both going on. They're both going on. They have a bit in the past. That's true. It's been usually the preserve of the left in the old days. In fact, of course, the Conservatives have, for hundreds of years, completely ignored the law, shot people, jailed them, and so on. They've hidden secret services underneath platforms to eavesdrop and so on. I'm not making any grand claim here, but what is going on at the moment is basically quite an attempt to get us to reinterpret what we mean by a democratic system. Take a couple of cases before I turn to the human rights point. Take a case called Majira. I did some critical comments on the Supreme Court recently. And one of my points was they're in the shallow end, I said. I've been going on about this for a long time, the shallow end. And so the shallow end is the easy bit, where all you're doing is complying with the rule of law. And I wanted them to be a bit more imaginative and so on and so forth. And this has been dealt with by the preceding speakers. I did not fully appreciate, this is a gloss on a piece I wrote. I did not fully appreciate how the executive actually wants to throw the judges out of the shallow end. So the shallow end is harder than I thought. We've had some of this on Ousted Clauses. But listen to this, Majira, from that, ironically today, from Rwanda. Rwanda, that beacon of human rights. I know it well, actually. I've visited, I've met the president, so I'm saying that now. It's a real sad story. But this guy is in jail, and he's out for good behavior and so on, and he's Rwandan, and there is a bail order. He gets bail. He's supposed to be sort of subject to immigration control now that he's out of jail, and the judge gives him bail. Fine. Judge forgot a few things. Busy. The critically Home Secretary did not remind the judge. The various things that he forgot were to do with ways in which you can control persons who are subject to immigration control. He gave him bail. His mum turned up and said, I'll pay if he runs away. The judge said, fine. So then what happens is the Secretary of State for the Home Department decides to impose a curfew on him. He's on bail, relatively unconditional. And so he's suddenly told that the Home Secretary has decided that he should be restricted. He shouldn't be allowed work, and he should be forced into a curfew. And his solicitor wrote and said, I'm sorry, we sort of have a judicial order. You know, slightly embarrassing. And the Home Secretary said, well, I don't care. And so this goes on a judicial review. And significantly, this is where it gets heavy, I think. Significantly, the court says, look, we're going to stay this application for a judicial review to allow you, the Home Secretary, to apply for the bail order to be varied. Why do I say that? I say that because there was a well-known system where if you don't like the conditions, you go back to court. Home Secretary said, no, I don't want to do that. I just want to ignore it. I want to ignore it. I'm just going to impose my own conditions. Goes to the Court of Appeal. The Court of Appeal say, surprisingly, in my opinion, didn't read the whole judgment actually for this, but we agree, it's a nullity. The judge made a mistake, it's a nullity. Case goes to the Supreme Court. It's decided on the 20th of October 2021, and the argument before the court is you don't have to follow a judicial order where you think it's wrong. No, I'm exaggerating slightly, where it's a nullity. The United Kingdom Supreme Court had to say this at paragraph 44 when the case came to it, overturned the Court of Appeal, re-established the judicial order. The Supreme Court had to say this unanimously. It is a well-established principle of our constitutional law that a court order must be obeyed. Wow! Shallow end stuff. And then further, paragraph 56. This is even in some ways more poignant. In the light of this consistent body of authority, stretching back to 1846, it is apparent that the alleged invalidity of the order made by the first-tier tribunal had no bearing on the challenge to the decision of the Secretary of State. It didn't matter. If he was wrong, appeal. If he was wrong, seek a judicial review. If he was wrong, seek to vary the order. You're not allowed, set it aside yourself. Now, why did the Home Secretary choose to push it to the Supreme Court? I'm going to talk a little bit about who's the guardians of the Constitution today in a moment. It's not the Home Secretary. It's not the Home Secretary. The case of Carter, the 23rd of February 2022, again, Home Secretary intervening, not really their case even, and saying this, paragraph 40. In written submissions, Counsel also contended that following the declaratory order, more on that in a minute, it was for any party who sought to rely on the provisions not commenced to apply for an order for specific performance. And in the absence of that, the declaration had no legal effect. Now let me tell you a little bit of law homework. When you are taking a case against the Home Secretary, I have a case, I'm a barrister, I have a case against the Home Secretary at the moment. What you seek is a declaration of unlawfulness. And what that is a statement that a particular provision is unlawful. It has been routinely accepted that the government abide by declarations and treat them as effectively legal orders concerning whatever it is that is declared to be invalid. In this case, Craig, 23rd of February 2022, in this case, Craig, the Home Secretary wanted to establish the principle that a declaration does not have the legal effect that it's been believed to have. And once again, the poor guy that I spent half of the year slating for not being me enough in other areas finds himself having to say, I'm terribly sorry, but declarations are sort of fairly important. And the only reason we do declarations is we're polite. We're polite. This case I've got, I mean, I can't remember the rules. I'm not going to be dragged before the Supreme Court. We've sought a declaration. There's a lot of money riding on it. It's the Home Secretary. And do we ask the judge if we win, judgment's awaited, do we ask the judge actually to quash because it's too dangerous to rely on declaration? It's a very interesting one. Very interesting one. What is going on? This is sort of conventionally understood as, in my mind, executive badge. They're not asking for legislative permission to ignore court orders. They're chancing their arm. Who are they and why? I blame Lord Irving. Some of you may remember Lord Irving. He might even be here. Because Tony Blair got fed up with Lord Irving, but was afraid to sack him. And his solution, he was the Lord Chancellor, when it was a job. When it was a job. He could pop into the House of Lords, adjudicate, as in the case of Boddington. He could do this, that, and the other. He could sack them all. He could tap their shoulder. I met that guy at a drinks party when he was Lord Chancellor. He said, "Go get me a glass of wine." I said, "I'm not one of your High Court judges. Get it yourself." So they abolished the post of Lord Chancellor, but they couldn't, because there were 8,558 statutory instruments that needed to be amended since Magna Carta. So they diminished it. And all the Lord Wolfs and so on got special claims in the relevant legislation. We love the rule of law. We love it. But what happened was he was replaced by whoever it was. I can't even remember. Jack, I don't know who it was. And then it was this person. Then it was that person. Then it was this person. Then it was somebody who didn't know anything about law. Then it was somebody who hated law. Then it was Dominic Raab. That person used to sit in cabinet and say, "Up with this, I will not push. Up with this, Lord Havers. Lord Hailshire." This is not a party political point. Lord Irving. These were substantial figures. Law, because of the lack of separation of powers, was central through the Constitution. Now it isn't. So I said I'd tell you who I think the guardian of the Constitution is. The guardian of the Constitution at the moment is Sir James Eadie. There is a figure, who may or may not be here, who seems to do all of the huge cases, who is the guy who has to decide whether to run an argument. And he is backed by the independent bar. I used to be enormously critical of the independent bar. I used to hate them. I used to hate their privilege and their treasures and their big swank dinners and the way they called each other master even when they were women. And now I love them. And the reason I love them is because we have got a tremendously lucky bunch of men and women now, who don't give a damn what the Prime Minister thinks, who support their judges and their lawyers, even where there is a risk of being ostracised. One of these Lord Chancellors, do you remember this fellow, big tall fellow, wrecked everything he touched, Lord Graham? I saw him at one of these feasts, way above everybody else, utterly ill at ease. And this is a world the government hates. And I don't think it's a world they can destroy. And what we need, society like this now, is to put a focus on the soft power you have in seeking to remind those who represent the government of these red lines, to use a fashionable term, conceding 9 or 10 points. Who's conceding? The lawyer is saying, "I won't go into court and do that." The lawyer is saying, "No." I've seen lawyers' concessions that they were forced to make arguments. This is a bulwark against executive banditry. It's less of a bulwark against legislative banditry. But up with this, we will not put, should be restored to the Constitution. Now, I'm very happy to talk about human rights. I'm just looking slightly at Nat. Nat, are you getting bored?
Couple of minutes.
Couple of minutes do me just fine. I think that's a bit mean of him. I thought he would say, "Carry on as long as you want." I shouldn't have invited him to be a tough chair. The human rights thing is of a piece with this. The government does not have the courage to repeal the Human Rights Act. Simpliciter. The Human Rights Act, Repeal Act. Simple to do, clear. It can't do it because the government is not powerful. The government's constrained by external situations. It's constrained by the European Union. It's constrained by the United States. It's constrained in ways that it cannot bear to admit because it's run by men, mainly, who see themselves as imperial overlords. And they cannot do it. They've claimed they can do it because they've pushed against the Human Rights Act because there was the word Europe in Schedule 1 and it was the battleground before Brexit on which were fought the European wars. But they can't do it. So what they end up with is they get poor Peter Gross to spend a year of his life investigating the Human Rights Act. And he gets a bunch of people for whom I feel equal pity to assist him in this dramatic job. And they produce a 400-page report. And they more or less say there's nothing wrong with it. And then the Lord Chancellor, Secretary of State for Justice, dispenses entirely with their report and publishes on the same day that he publishes that report his own thing. His own thing is nonsensical. It won't repeal the Human Rights Act. It describes the need for a Bill of Rights, which in almost every single particular will be exactly the same as the Human Rights Act, except that it will modify the word reasonable with pretty reasonable. Or it will say sort of follow but really don't very much, Strasbourg. It's a nonsense. It's going to find a whole lot of rights, including a right to a jury, and then they remember, A, it's not in Scotland, and B, we don't have it here anyway. I was looking forward to deliberately littering, by the way, and demanding a jury trial. It's nonsense. Now, some people who need work from the government can't say that. I said it's nonsense. It's nonsense. But it's happening because it's still part of a war about Europe. And the Joint Committee on Human Rights, I declare an interest, I did give evidence. There is I have to say, a brilliant cross-party refutation of the nonsense. So I end with this. There is still the possibility of accountability in the Constitution against executive banditry and legislative banditry. There is still the possibility. It depends, in our world, on government lawyers and those of us who are engaged in law supporting them. And it depends, we saw it yesterday, on elected members of Parliament actually finally saying it's gone too far. And I was very pleased. I may have misread this, and I think Alison and Conor will tell me, but I don't think there's any dissents from the Joint Committee on Human Rights. So it's a cross-party group, and it's a destruction of the government's policy, a destruction of it. And so if we have a restoration of kind of conservative values within the Conservative Party, and we have further an acceptance of the need to support lawyers when they stand up to government, the Constitution is, I think, rescuable.